Alrighty, so let's welcome Gordon Byars to the podcast today. Gordon, how are you?
I'm doing well. How are you?
Yeah, I'm doing fantastic. It is such an honor to have you here on our podcast, on our channel. I finally got you here. I'm very happy. So cool. So I got some questions for you today, and I'm pretty sure you've got some really good answers for me.
Yes, sir. I'm gonna try. I'm gonna try and give you the best answers I can.
All right, all right. So the question of the day, the very first one. So um So in terms of like effective client communication, right, in criminal defense cases, like how do you ensure transparent and open communication with your clients throughout the criminal defense process?
So it starts on the front end at the very initial consult. You need to set their expectations about
Hmm.
what level of communication that they can expect to have. When people come to see me, citizens that are accused of crimes,
Hmm.
they're at a very low point, and they want to speak with you every day if they can. They want reasonable assurances that things are going to be okay. So you
Right.
start in that consult by explaining to them that we're at the early stages. There was
Hmm.
not a lot of information that we have right now. We will update you as things progress, as updates come. In the meantime, we utilize a client case management software called MyCase. They get login credentials to that MyCase portal, and we maintain our entire client file there. So every time something happens, it gets
Uh-huh.
shared with them and they have an opportunity to look at it. Anytime something material changes in their case, we send them a client communication, a message on the MyCase portal explaining it in writing, and then we follow up with a phone call. Another
Mm.
really, really effective tool in client communication that not all lawyers, I think, appreciate is good, knowledgeable staff. We, as the attorneys, have very busy calendars, and it's quite difficult sometimes to get on the phone with each and every client every day. So
Hmm.
you want to have a staff member that you work hand in glove with that understands what's going on in those cases and can give those client updates. Also, and more importantly, to keep those processes streamlined so that we're not wasting their time or ours. When a client calls in and has a question about their pending case, you want to have a staff member that can get as much information from that client about that question to share with you before you call them, because then we can turn an otherwise 30 or 40-minute meeting into a super short phone call. And a lot of
Right.
times it's just about reasonable reassurances. They want to make sure that things are progressing. They want to make sure that, in a lot of situations, that they're not looking at jail time. And that's where
Hmm.
that first meeting really matters. You have to
Mm.
set their expectations appropriately. In a simple possession of marijuana case, you can reasonably tell your client the chances of you having a single minute in jail are very, very low.
Oh.
When you're consulting with someone that's charged with a child sex case or a homicide or a crime against a person,
Hmm.
the likelihood of a jail sentence is much, much higher. And you have to start setting those expectations on the front end. That's really going to drive the bus on how much client communication they're going to expect.
Oh, I got you. So yeah, looks like there's quite a lot of data in there. So ultimately, you wanna build a strong type communication with your clients the moment they show up,
Mhm.
right?
You have to
And
develop that rapport. If you don't have a
mhm,
good rapport and trust with your client, then maybe
mhm,
you're not a good fit for them.
mm,
You need your client at the time they hire you to believe in you, to trust you, and you have to have a good vibe with them. You have to
mm,
get along with them a little bit.
mhm,
If you can't get along with them, then they're not going to trust your advice. And there are circumstances, I've seen numerous situations where a client turns down good advice from a lawyer just because there's some riff in their relationship. So I
right.
really frequently will tell clients, if you don't feel like in your gut that I'm the guy for you, then you
Hmm.
need to probably consider someone else,
Hmm.
because that's what's ultimately going to benefit you, is that you've got to have, especially in the criminal defense world, a strong relationship with your client. If you don't, they're not going to tell you the truth about the bad things going on in their case. They're
Right.
going to listen to your advice. They're not going to believe you're working for their best interest, so they're going to call every day. And it's just not a good business relationship.
Right. Right. Definitely. All right. Well, that's a really awesome answer there. So now moving on to the next thing here. Now, when building a defense strategy, right? That is the next phase of things, building defense strategy. So now, can you share examples of best practices you employ when developing a comprehensive and effective defense strategy tailored, specifically for criminal cases?
hmm So the first thing that we have to do in a criminal case to build an effective defense strategy is to identify what do we believe the outcome levers are. What are the
Mm,
things that we need to know to be able to change the outcome? Some cases, they're very fact dependent. So in those situations, you need investigators to get out and interview witnesses and gather facts. You have to remember that the district attorney's office, the government, the
mhm.
state, they have a whole police force out investigating cases.
Right.
Some cases are witness and fact dependent, and those are the things that are going to change the outcome. So in those situations, we need
Mhm.
investigators. We need competent, trained, usually prior law enforcement that are in the later parts of their career, to get out and gather information and gather facts, just like law enforcement's do.
Mm,
In other cases, you can identify on the front end that an outcome lever, and when I mean a lever, the thing you can pull to change the outcome.
right.
Some of those are very science dependent, right? If you've got
Mhm.
an arson case or a child sex case involving DNA or a sex case involving DNA, then you're looking more towards your defense strategy relies on science. Sometimes you have to retain experts that are experts in particular scientific fields, in addition to fact investigation. And then
Mhm.
sometimes there are outcome levers that are not really fact dependent and are not really science dependent. They're law dependent. Can we develop the proof we need to show that this law does not apply? And
Hmm.
how do we do that? We do that with a combination of fact witnesses and expert witnesses. And
Right.
then the wild card sometimes can, we believe in looking at a case that there's some societal viewpoint that is outcome driven. We practice in a lot of rural areas and we practice in a lot of urban areas. We're located between Nashville, Tennessee and Knoxville, Tennessee. The juries I'm going to get in Nashville, Tennessee are vastly different than the juries I'm going to get in a rural area with a much lower population. So sometimes societal viewpoints are really important. In those situations, we employ people to do comprehensive social media reviews of potential jurors, potential witnesses. We want to figure out what their viewpoint is, their societal viewpoint. A lot of times it's political, sometimes it's socioeconomic. But
Mhm.
if I've got a young man of color charged with a very ugly crime in a rural area,
Mhm.
that's different than defending the same gentleman of color in Davidson County in Nashville, Tennessee. And there are things you have to consider. So in those situations, what we've done with some great success
Mhm.
is do focus groups. And focus groups sound like they're really complicated and expensive, but they're not. You
Mm.
solicit a group of citizens from your area. Usually we offer them lunch, and some refreshments,
All
and they're
right.
all usually very interested, and you bring them in and you give them the facts of your case and you listen to their feedback, because that's
Mm.
how you're really going to understand what the societal viewpoint is. We as attorneys a lot of times get tunnel vision,
Mm.
uh, and believing our clients, and we need an outsider's perspective on, we've developed this factual defense strategy, we've got our experts, we believe that we've got a winning formula, but does that juror or that person that's going to hear our proof, do they agree?
Mm. So
So
ultimately, there we're looking at public opinion, basically, in
yes,
that area.
these are going to be tried by juries of your peers, and unfortunately not always are these juries truly made up of your peers.
Mm. Got, got you. All right. I'm sure the viewers here are going to be very well informed on this one here. And then so here's the next segment now. This is going to be on ethics, right? When it comes to criminal defense.
Mhm.
So now, because I know that at times there's this little fine line at times between, crossing the line between ethical and unethical. So, like, how do you approach and navigate ethical dilemmas?
Hmm.
as a criminal defense attorney? And what best practice do you follow to maintain the highest ethical standards for you personally?
Hmm. So what ends up happening, the main area of ethical considerations we have in criminal cases are cases involving more than one citizen charged with the same crime. They're
Mm,
co-defendant cases. So on the front end, best practice is very important to ensure that if you get a phone call and consult with one of those co-defendants, that
mhm,
you are now forever barred from ever consulting with the other co-defendants. So you have to ensure that, say on a Monday, I meet with a person who's charged with a first degree murder, and he has
right.
a co-defendant charged with that same first degree murder. We have to ensure that we find out who that person is on the front end and make sure that we don't then subsequently meet with them. So the way we do that is we have conflict checks through our case management software and our calendar system.
Mm,
That would, excuse me, that would be very bad to meet with one and then meet with the other. And the main reason for that is in the meeting with the first person, they enjoy attorney-client privilege for candid communications. And you
mhm,
want them to tell you the truth about what happened so that you
right.
can evaluate their possible defenses. Well, let's say on Monday I meet with that first gentleman and he tells me the truth about what happened. And
Mhm,
then on Thursday, through some problem, I meet with the other co-defendant and he tells me something that I can use to help the guy I met with on Monday. I can't use the information he told me on Thursday because he enjoys confidential client communication. In that
uh,
situation, I can't represent either one of them
oh,
because
wow.
I've learned something on Thursday that I have a duty to use to help the guy on Monday, but I'm ethically prohibited from using it because I learned it in confidence on Thursday.
Wow.
So the main focus is making sure you never conflict yourself out like that.
Mm,
That works with former clients as well. So let's say I represent someone on a domestic assault case in
mhm,
2020, the husband. And in 2023, the wife comes in to hire me for something
mhm,
criminal in nature. I can't represent her because I may have learned information about the husband or about the wife from the husband earlier in time that I could use to help her, but I wouldn't be able to use it because I learned it in a confidential manner, and I can get in trouble for that.
mm,
The other main thing that I think criminal defense attorneys have to be cognizant of is you heard me talk about those fact investigations where you're
right.
interviewing witnesses and you're getting out and pounding the pavement. A
Mhm,
lot of lawyers do that themselves. And the problem with that is if you learn something from someone, let's say I meet with a witness and they tell me something,
mhm,
and later in time they get on the witness stand and they say something different than what they told me.
mhm,
The only way I can prove that what they said is different is through my own testimony. So I've just turned myself into a witness, and I can't be the lawyer and the witness.
mhm,
So you need a third party investigator or you need recorded conversations to make sure that if what they're telling me today is the same thing they tell me when we get in court, because if it's not, I got to show that they're lying. The only way I
right.
can do that, I can't just stand up there and say, well, that's not what you told me, because I'm.
Right.
So you've got to make sure that you don't create, and it's easy to do,
Mm,
create a conflict in that you become a witness. And the best way to do that is to always have a third party, another lawyer there as a witness, a staff member. If you don't have the resources to be able to have an investigator, you get a
mhm,
staff member. Um, and I think best practice is a third party investigator who's trained
mhm,
in those things. And the ethical guidelines say that to be effective in terms of effective assistance of counsel, the
mhm,
lack of using an investigator can fall below the standard of care required of us. Because it all really boils down to the fact that the police department has a whole team of investigators, and we're not just going to take their word for it.
right.
They're not on our side. This is an adversarial system. So we need an independent person who's just as well qualified to
Mhm,
fix these facts. And if we use that independent person, we're following our best practices because we're never conflicting ourselves out.
right. 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 All right. Thank you very much for that. And then now moving on to leveraging technology in defense. I'm sorry, in criminal defense. And what I mean by that, or my question for you in that regard is like In what ways do you leverage cutting edge technologies to enhance the investigation, research, and presentation of evidence in your criminal defense cases?
So to begin, the investigation portion has just changed in leaps and bounds in probably the last 5 years.
Oh,
Um,
wow.
we now have access to significant amounts of digital evidence, everything from body cameras worn by police officers now. Those
Mm.
are now generating high definition, gigabytes upon gigabytes of video of exactly what occurred. We didn't have that 5 years ago. It was maybe 1 in 10 had those. Now it's 9 in 10. So we're getting hours of video. We're now also getting, and we're able to get either independently on our own or through the district attorney's office, cell
Hmm.
phone data. We get terabytes of cell phone data. And that includes things that the user can see, but it also includes things on the phone that have been deleted that we can
Oh,
see.
wow.
We have probably something that comes up in almost every case, in addition to the cell phone data, is there's this incredible misconception amongst the public that Snapchat communications disappear. Well, they don't. They just disappear for you. I've tried first-degree murder cases where Snapchat communications are on 20-foot screens. And
Oh,
people think they're gone. They're not. We can get through judicial subpoenas Snapchat communications and videos. It's even getting really kind of intense because we are also now able to get, and so is law enforcement, Ring video doorbell footage,
wow.
Google Home Mini recordings, and Alexa Echo recordings. Shooting happens in a living room that's got an Alexa in it, and I can
Hmm.
get audio recording of everything that took place in that room.
Wow. Okay.
Making things even more complex, in
Hmm.
some bigger cities, they have camera systems that are on poles that are high definition cameras that sync to gunshot speakers. So in Davidson County, in Nashville, Tennessee, in Atlanta, Tennessee, and in Memphis, or in Atlanta, Georgia, and in
Hmm.
Memphis, Tennessee, specifically that I'm aware of,
Hmm.
uh, they have shot positioning microphones all over the city. So a gunshot rings out, the microphone picks it up. Within seconds, the camera on the pole that's producing a high definition image points at the origination of the gunshot. We're now seeing cases where gangland shootings, they're getting video footage of our clients with guns in their hands because it's happening so fast.
Wow.
We can do crime scene reconstruction with a device called a Pharaoh, where you set up markers and create a complete digital recreation of the entire crime scene. It's really handy for bullet trajectories
Hmm.
and crash reconstruction. These are all things that just didn't exist 5 years ago. They existed for the government. 10 years ago, they didn't exist at all. And
Wow.
so
That's
now
crazy.
we're getting, and everyone has a Ring video doorbell, and everyone has surveillance at their house. And
Hmm.
so I can even get Wi-Fi data. So let's say someone's accused of a crime and they're driving down a main thoroughfare in Atlanta, Georgia, or
Hmm.
Nashville, Tennessee. Well, their phone is not actually hooking up to all the Wi-Fi hotspots that they're driving by, but their phone is interacting with them, right? So if I'm driving down Broadway in Nashville, Tennessee, every business that has public Wi-Fi, my phone is telling me that it's available to connect to. Well, when you take that data, even though the phone's not connecting, I can
Hmm.
basically see exactly where you're traveling to based on your phone's interaction with Wi-Fi hotspots. I
Wow.
can track it.
Okay.
When it comes to presentation of that evidence in
Mhm.
criminal cases, it's remarkable. A lot of courtrooms nowadays have screens available for jurors, judges, witnesses, and you can cast to that device from the podium, manipulate the content on that screen, and it has
Mhm.
completely streamlined the presentation of evidence. Instead of printing out 100 versions of this photo to pass out to everybody, I just populate it to all the screens, and I
Mm.
admit it to evidence electronically without actually having to manipulate the document. I can play videos, I can enhance videos, I can slow videos down. Um, this stuff just didn't exist years ago. It wasn't a thing.
Right.
Uh, it's made the presentation of evidence much more clear. It's also affected jurors in a way that's interesting. They expect you to have video. they expect you to have forensic evidence. If you don't,
Right.
there's a problem.
Mm.
Sometimes we can make that work for us. We can point out that, jury, you would expect them to be able to have video of this. You would expect them to have DNA, but they don't. And that's why my client should be acquitted of these charges.
Right.
The legal research is kind of remarkable too.
Hmm.
Recently, Thomson Reuters Westlaw has come out with, which I'm on a trial basis of right now,
Hmm.
an AI, closed source AI that they've developed of their legal research database that's plain language search. What they are trying to explain and what they believe is that this legal research software is so sophisticated using their AI model that it takes the place of a first-year lawyer who's doing research tasks. And it's, you can talk to it just like you're talking to another lawyer. In the 3 weeks or so that I've been using the trial, it's remarkable. It has
Wow.
been an absolute game changer. It
Hmm.
kind of makes me think that it's going to cause lawyers to have some job security issues. It's that good. And it's only going to get better.
Hmm.
You know, where I used to spend hours and hours looking for a particular case, I, I have generated those same cases through one prompt on this AI software.
Wow.
And
So we.
I have to pay
Mhm.
for it and adopt it to keep up with the district attorney's office. I lost a motion hearing recently on some esoteric issue, and it turned out they have that AI software, and that's how they found it.
Wow. So with it's because some of these things you're describing to me, basically, it's almost like I'm in a video game. Just because the evolution of technology when it comes to going to court and things of that nature. That is something for sure.
And you know
Um.
what really advanced it light years in the court
Mhm.
system was COVID. We still had to have court proceedings. We couldn't shut them down, but we couldn't bring groups of
Oh.
people into courtrooms. We started having trials on Zoom. We started having court appearances on Zoom. It really advanced courtroom technology leaps and bounds in just months.
So ultimately creating it basically the COVID created a necessity for that,
Correct.
basically, because we're all in our houses and stuff. Okay. Okay, cool. So now here's the next segment here. So this is gonna be in regards to preparation for like preparation and investigation, right?
Mhm.
So like could you elaborate like on the importance of thorough pre-trial preparations, right, and investigation in building a solid defense case? Like, what specific steps do you take?
So the first thing, and I touched on it earlier, is you have to get all of the information possible, and you have
Mm-hmm.
to kind of bring it to your table. You
Mm.
need all of the witness information, all of the witness statements, all of the police statements. You need all of the electronic evidence that you can possibly obtain. By the time you feel like you've got all that,
Mm-hmm.
now we kind of cook up our strategy. We're looking for two things. We're looking for a theme and a theory of the defense. The theory of the defense is the legal reason why your client has not committed the crime. You
Mm.
can't really determine that theory until you have all the evidence. Then you're looking for a theme, which is, what is your theme? What is your positive theory of the defense on why they are not guilty? This is more an emotional thing, the theme. The theory is legal, the theme is emotional. We kind of cook all that up into a theme and a theory. And we try to find things, facts that are facts beyond change, meaning
Mm-hmm.
facts that we cannot do anything to change. And we look for those facts that fit our theme and our theory. If we can't find facts that fit our theme and our theory, that means we have the wrong theme and theory.
Hmm.
Then, armed with a good theme and a good theory, we spend a considerable amount of time, and sometimes we use those focus groups that I alluded to,
Mm-hmm.
preparing for trial. Trial preparation is fairly intense. In my firm, we shut everything else down and we engage in trial preparation. And clients understand on the front end that when it comes time for us to prepare for trial, we are not going to be as openly communicating with other people at that time, because it's that client's turn to have our attention. And when it
Right.
becomes the other client's turn, they'll get our full attention. But it's an all hands on deck thing. I tried a case in September involving injuries to a child, very significant injuries to a young baby. It was a 4-day jury trial. We probably spent 250 hours, the team of three, just the preceding month, getting ready for that trial. 17 witnesses testified. You have to prepare cross-examinations for all 17 of them. We had 3 doctors testify. You have to learn everything you possibly can about those doctors, what they've said before, where they've said it. Have they always
Mhm.
testified for the state? Do they sometimes testify to the defense? Are they hired guns that just testify the way you want them to? And then eventually you kind of cook it all up, because you have to have a consistent theme and theory. What you argue to that jury in opening has to be consistent with the proof they're going to see, and
Mhm.
it has to be consistent with the closing that you're going to offer them. Because if not, they think you're lying to them. They think that
Right.
you're engaged in smoke and mirrors. They think lawyers are engaged in lawyer tricks. And if you don't have the appropriate, because by the time we're going to trial, that
Mhm.
means that the district attorney's office and our defense team have a fundamental difference of opinion about what the facts show and what the law says. If we didn't have that fundamental difference, we
Mhm.
would settle the case on a plea agreement. But because we have this fundamental difference, we have to determine, how does the law apply to the facts, and what will the jury think about it? How does that witness present? If I read their transcript, it sounds very damning to my client, but how do they present in person? Can they actually convey that to a jury? Can they convey it in a way that's believable? What kind of documents are going to change the outcome? Can we get those in? Are they admissible? If they're
Mm.
admissible, do we need a live body to get them in, a witness? Or can we get them in through some other exception to the evidence rules? And at the end of the day, you have to be able to flow with your
Mhm.
trial prep. There has to be a rhyme and a reason to it. It has to
Right.
make sense. You can't just go in there and throw things at the wall. It doesn't work. That's how people go to prison.
Mm.
Also can't go in there. You have to have a positive theory of the defense. My client is not guilty of X because insert positive theory of the defense. What a lot of young lawyers do in their trial preparation is they get focused on the fact that they think this district attorney's office or the state can't prove their case. I would suggest that that's what I call the reasonable doubt trap. They go in there and argue that there's reasonable doubt and the state hasn't proven their case. If
Mm.
you are arguing that the state, if your main argument is that the state's not proving their case, you're losing. You just don't know it yet, because
Mm.
the jury already believes the state. You're not required under the Constitution to prove your innocence. But my position is that juries expect that. They expect you to put on proof and show why your client is not guilty. And they don't expect, it's not a winning argument to just get up there and shit talk the DA's office. It doesn't work.
Right.
You've got to tell a story to a jury that touches on an emotion that they can understand.
Mhm.
That emotion has to lead them to one logical conclusion, and that conclusion is your client's not guilty of what they did.
Right.
And
Right.
sometimes that doesn't mean they're not guilty of everything. If you're charged with a first-degree murder, beneath first-degree murder are 5 or 6 different forms of homicide. Maybe your client killed someone, but they didn't do it that way. They didn't commit a premeditated first-degree murder. Maybe they did it in a heat of passion. Well, the difference between being convicted of a first-degree murder and being convicted of a voluntary manslaughter under heat of passion is
Mhm.
enormous. First-degree murder in Tennessee carries a life sentence, which is 51 years to serve.
Oh,
Voluntary manslaughter carries a penalty of 8 years.
well,
So,
that's a vast difference.
yeah. So sometimes you're not arguing to the jury that your person is pure as the undriven snow, that they deserve to go home.
Mm.
Sometimes you're arguing, yes, my client did a bad thing, but they didn't do that bad thing. They did
Mm.
this bad thing. Because the jury's not entitled to know what the penalty is. But you know that if they agree with you that they did this bad thing and not that bad thing, the difference is 42 years in prison. And that's
Wow.
why effective trial preparation and understanding those issues and those outcome levers is the most important part of the entire process.
Got it. Okay, so ultimately here, an attorney that can actually get the jury on their side, not just by trying to prove uh prove the state wrong ultimately, but actually, give the reason why,
Hmm.
or be positive basically in your
Hmm.
presentation of your case is something that can basically help you,
Right.
right?
Give you a good
Um,
example.
mhm,
Self-defense is a great example.
mm,
At the core of self-defense is fear. Someone is acting on me in such a way that I am afraid of imminent bodily injury or death. And as a result of that fear, I act, I do something.
mhm,
Well, if I stand in front of a jury and I tell them about fear, they don't, it doesn't make them feel anything. They don't, I can describe fear for you for days, but it's not going to make you feel fearful. The
right.
better strategy is in jury selection is to ask the jurors about the time they felt most afraid and start
Mm,
getting them to create those emotions in their own body and in their own mind.
right.
And then you pull your facts through that fear. I
Mm.
can't tell you about fear in the same way that you can recall your own fear.
Recalling and making them kind of experience
Yes,
what it was like.
right. And you
Mm,
listen to what they have to say and you use that. And you say things like, and Mr. Doe over here felt the same kind of fear as when you had this go on in your life.
mm,
It's so much more effective than just
mhm.
describing it.
Right, right. Because emotion is something that is, people respond to emotion, right? People respond to emotion pretty well.
Yes,
So yeah, I can relate with that definitely. Definitely not the description of the emotion, but the
the
actual
actual.
emotion itself.
Mhm,
Right.
mhm,
Alrighty. So now on, like, the next subject here is gonna be on negotiations and plea, bargaining skills, right?
mhm.
So, like, how do you approach negotiating, like, say, negotiations and plea bargaining to achieve best possible outcomes for your clients in criminal defense?
Mhm. Well, the first step is know the prosecutor you're dealing with.
Mm,
Prosecutors, assistant district attorneys, uh, assistant United States attorneys, they're all still human beings.
mm,
And knowing what they like to see and hear really helps. Some prosecutors take a hard stance on drugs. Some prosecutors don't. Some prosecutors take a hard stance on anytime you run from the police, I'm gonna make you go to jail. Some
mm,
prosecutors don't. Some prosecutors take a hard stand on crimes against people where a person is hurt. Some prosecutors don't. A good example is we in my district have two different prosecutors that I deal with frequently. One of them has a really strong opinion about how illegal marijuana is. The other one is 29 and a little more progressive in that viewpoint.
mm,
Don't think it's that big a deal. So the first step is know your prosecutor, right? The second step is know the facts of your case. Understand where the state has flaws.
mhm,
But it is not effective negotiating to go and point out those flaws to the prosecutor. Because what you'll find is they'll say, I know what's wrong with my case. I don't need you to tell me. What I need you to tell me is why we should settle it. And there's all kinds of motivations for settlement. If you're dealing with a property crime where someone had some property damaged or something taken,
mhm,
most often the prosecutor's goal is to make that person whole. Knowing that makes you an effective negotiator. Instead of going to the prosecutor and saying, my guy's really sorry that he drove through that fence and destroyed it, can you please dismiss this case? You go to him and say, my guy's really sorry. He went out to the home, he fixed the fence, and he paid all the restitution. And the victim, because I've talked to him, they're totally fine with you dismissing the case. You're saying the same thing. You're
mhm.
asking for the same thing. You're just giving different reasons. Um, on a drug case where you've got someone that is in active addiction, the fact that they're in active addiction and that they had trauma in their past is very relevant to the prosecutor in explaining why they're acting the way they are today. If you have a crime against a person and that person was an initial aggressor, that's important. What does that person's background look like? If my client gets into a fight and hurts a person that's been charged with 25 assaults, that certainly indicates that maybe this was a mutual combat situation. So knowing your prosecutor and knowing your facts are incredibly important because then you can find the area that the prosecutor and you can agree on.
Hmm.
Um, Understanding what the client wants and what they're willing to take and what they're not willing to take is really key. Knowing your client through this whole process is probably the most important thing, and understanding where they want to be at the end. Give you an example. I
Hmm.
represented many people that have spent considerable periods of time incarcerated. Those people are usually fairly realistic, and they come to you and they say, look, I did this, but I didn't do that. I understand I'm going to have to go to prison on this. Get me the best deal you can. Well, everybody, nobody wants to go to prison, right? So
Right.
you go to the prosecutor. Sometimes the prosecutors will start off by saying, don't ask me for probation. And you can turn around and go, no, no, I've already talked to my guy. We know we got to go to jail on this, right? We
Right.
know we
Hmm.
got to go to jail. And what you're doing is you're disarming that prosecutor, because they're already like, okay, we're on the same page. We
You got the
understand.
guard off. Yeah.
Right.
Hmm.
And you really just kind of can massage that situation. If you've got a guy that spent 10 years in prison 20 years ago and he has to serve a year in jail, I've had clients say, man, I can do that on my head. No problem. If you've got a housewife that's done something stupid that's never been to prison before, the idea of serving a day in jail makes her have an anxiety attack, right?
Right.
Another really good trick for negotiation that I found to be very fruitful is if you have a client that is in a position. So a lot of times prosecutors will start off, if you've got a first-time offender, offering probation, long probated sentences. Well, let's say they offer you 8 or 10 years of probation. 8 years on probation is very difficult. That's really an impossibility, right?
Mm.
If you've got a person that's actively involved in drugs, actively involved in a criminal lifestyle, asking them to completely turn their life around, stop doing what they've been doing their whole life, and be good on probation is not very realistic.
Mm.
And what ends up happening is the prosecutor knows that your client can't serve 8 years on probation. And they know that if your client violates probation, they're going to get to put their sentence into effect and get them 8 years to serve to begin with,
Right.
right?
Hmm.
So what I find to be effective is you explain to the client, look, we're going to have to go to prison, and they're on board. They understand that this is a bad case. The prosecutor offers you probation, but your client admits and you know they can't do probation. So this is where you turn it on the prosecutor. You go back to the prosecutor and you say, listen, my guy ain't going to take 8 years probation. He can't do it. So make me your best offer to serve in prison. And I've seen offers of 8 years probation go down to 2 years to serve. Your client goes and serves that 2 years, they come out, they don't have any probation. It's about knowing your prosecutor. And your prosecutor thinks they've won. This guy's going to prison. I'm going to get them off the streets. And then, of course, there are factual reasons why they should plea. And then there are legal reasons. Occasionally, your client gets charged with something that's not really what the facts show. And you go show
Mm.
the prosecutor, hey, you charged my guy with this, but this is what happened. And this isn't the appropriate charge. And
Mm.
you work through it.
Right.
Um,
So sorry to interject here, but can you do you have an example of that, like an hypothetical example of that actually happening?
which one? Which one?
As in a someone being charged with something that's not quite the case. It's not quite what happened, like
Hmm.
the sentencing don't quite match up, right?
Hmm.
Like you just mentioned.
I do, yeah. It comes up most frequently. I handle a lot of cases involving child sex cases.
Mm.
In Tennessee, it is, of course, a crime to touch a child in a sexual manner.
Hmm.
It's aggravated sexual battery. And the level of crime depends on the age of the child. It is a very different crime to penetrate that child either orally, digitally, or with a sex organ, right?
Right. Hmm.
A lot of times investigators, because they know how serious the rape of a child charge is, they try to incentivize witnesses to say there was penetration. I've seen this probably half a dozen times where a person is charged with rape of a child, which in Tennessee carries a 25-year prison sentence. It's a mandatory sentence to serve in the Tennessee Department of Corrections. Then you get the forensic interview of the child, you get all the medical records, you get all the witness statements, and it's very clear that this person touched this child,
Hmm.
but they never penetrated in any way. There's no evidence of penetration.
Mm-hmm.
Well, that means that what they've committed is an aggravated sexual battery. And in Tennessee, an aggravated sexual battery is 8 to 12. And it's eligible for probation.
Mm-hmm.
All of these crimes end up on the sex offender registry. But you go to the prosecutor and you go, there's no evidence of penetration at all. And for my client, that's as much as a 13-year change in penalty. And very frequently, when you show that to the prosecutor, they agree
Mm.
and you ultimately reduce those charges. Happens a lot in murder cases. First degree murder gets charged a lot. And then you're able to demonstrate there was some heat of passion, self-defense, that the facts don't support an intentional, premeditated killing. But
Mm.
they do support second degree murder, which is the knowing killing of another, or voluntary manslaughter, which is the killing of another after adequate provocation. And so you go show the prosecutor, hey, you got this charged wrong. And it's a big deal for the client. Um, you're not going to plead guilty to a first degree murder and take a life sentence when they don't have any proof of premeditation or deliberation. It really boils down to what I think is a ubiquitous problem with charging people with crimes. It's been my experience that a lot of prosecutors overcharge,
Mm.
and then that gives them room to come down.
Got it. Okay. Okay. Now that would make sense why you have this much, and probably they're already thinking like, okay, cool. Maybe I could go down to maybe 2 years. So they
Right,
could just
right, yeah.
it's
And
like a bluff.
right, that's right.
Mhm.
And the only way you can figure that out as the attorney defending these citizens accused of crimes is to
Mhm.
have a strong understanding of the facts, a
Mhm.
strong understanding of the client, and a
Mhm.
strong understanding of the law. And that just takes time and work.
Right.
You don't
All
know
right.
that on the first day you meet them, but
Mhm.
you figure it out over time.
Right, but that's which then now that we're talking about it, it goes back to the very first question that we brought up on this in this interview, which was knowing your client, you building a good relationship with them, because then they can talk to you and then you
Mhm.
can get all this information out of them.
Right. And I will tell you, and I've some of the clients I've liked the most,
Hmm.
I've told them to this to their face. The first time they meet with you, they are
Hmm.
not telling you the truth, because they're human beings and they
Right.
want to tell you the most mitigated version of the truth possible. If they're not going to just admit to all the bad facts because they don't know you, you're a
Hmm.
stranger. So I may have a client that walked into a gas station and killed somebody, but he's not going to come in and say that. He's going to tell the most mitigated, least involved version of that story he could possibly tell me. Well, that's not what I need to hear. I need to hear the worst possible version. And I
Mm.
don't expect you to do that not knowing me. So I've got to build that client trust. And the way you build that trust is through your communications, your interactions, and then letting them see you work for them, letting them see you do things, showing them that there's surveillance footage and I'm going to get it. And then you go get it and you build that trust.
Mm.
Another way that I really like to do it on first couple client meetings, and I learned this from a much older lawyer that I think does a great job.
Mhm.
Instead of asking them, tell me what happened, I say, tell me what lies the police are going to tell about you. What are they going to say? What's the worst thing they are going to say about you? Because it has a way of disarming someone and going, well,
Mm.
I didn't do this, but they're going to say this. And then you start getting closer to that truthful story. And after about the fifth or sixth client meeting, and after a few motions, and they've seen you do good work on their behalf, you get that, hey, I need to talk to you. And they go, well, I need to tell you this. And it's a process, and it's building blocks.
Mm.
But if you care about it and you try, you will build those blocks. Like you will build that relationship.
Right.
You just phone it in and don't try, you're never going to build that relationship. And there may be something that your client is holding back that could break their case wide open. And they're holding it back because they don't know you and they don't trust you.
Mm. Which makes sense because, like you said, we're human beings. You
Mhm.
tend to open up people. You tend to open up to people you trust, right? So yeah, ultimately. Okay, so now in this next section is gonna be on witnesses, right? Witness selection, right?
Mhm.
So like what criteria do you consider when selecting expert witness, and how do you present their testimony effectively to support the uh case?
So the first thing is you identify those outcome levers I talked about.
Hmm.
If you have a rape case
Hmm.
and the most important piece of evidence is DNA, well, you cannot just rely upon the state's DNA expert. You have to get your own DNA expert. If you've identified that DNA is going to be a material issue and it's going to change the outcome, you have to find your own defense expert. And I find the best way to do that is honestly just word of mouth. I'm a member of several different professional organizations that are for criminal defense attorneys. So
Hmm.
my first step is always we have a message board, and I shoot a message out and I say, hey, I need a defense expert for serology or DNA.
Hmm.
And you get a couple of names and you start looking at those names. And the first thing you want to know from that expert is I want to see your CV, I want to see your credentials, I want to know what your fee structure is. And do you travel? And do you do these kinds of cases?
Hmm.
Once you've identified someone that is qualified, right? Because the state's going to have their expert and you already have a copy of that person's CV. So you need somebody equally qualified. You don't want to hire somebody that's not as qualified. A good example of that, I watched this blow up on a guy one time. The state had a psychiatrist and he brought in a psychologist. Well, the difference between a psychiatrist and a psychologist is a medical degree.
Right.
And so the state's expert actually testified when asked, well, why does he have a different opinion, referring to the psychologist? And the state's expert said, he just doesn't know what he doesn't know. And the jury believed that because you got a physician versus a master's level, right? So you want somebody with similar credentials.
Mm.
And then I want to know, do you always testify for the defense or do you sometimes testify for the state? I want a defense expert that is neutral, that testifies for both sides. Because the last thing I want to have happen is the state to argue that I've just got a hired gun to come in that only testifies to what I say.
Mm.
The third consideration is how do they present to a jury? Are they effective? Sometimes in these hard science areas, DNA, medical testimony, fire testimony, these people are scientists and they're not super magnanimous. They're not super, they don't have a lot of energy, good energy in front of the jury. And I've watched that blow up. I've seen two doctors testify, and one younger, attractive, very charismatic female, and
Hmm.
one older, mean, curmudgeon male. And they both say they both have equal credentials, but the jury believes her because they like her more.
Mm.
So we want experts that can testify, that have got experience testifying, that can communicate with juries on their level. I don't need a doctor to come in and recite a medical treatise. I need a doctor to come in and explain to the jury the medical reasons why in lay terms. And not
Hmm.
all experts are capable of that. They talk
Right.
over their head. Can't have that.
Mm.
Then you start off by engaging your expert and you've got to give them some confidentiality requirements. You don't want the district attorney's office to know you have this expert until you've decided to use them. So you want them to be completely confidential with you, and you do not want them to write any reports until you've discussed it first. Let me explain why. This is pretty
Hmm.
key. Let's say I've had this happen. Let's say I hire a firearms expert. No, I got a better example. I hire in a vehicular homicide case a crash reconstruction engineer to
Hmm.
evaluate whether or not my client had a loss of power in his vehicle immediately before the crash that killed an infant. And this is an actual case we did this year.
Mm.
My client tells me that there's a power failure and that's the reason why he crashed. So I hire an independent expert to evaluate whether or not that happened. But before that expert writes a report, a written report as to whether or not that happened, I tell them, I want to talk to you before you write anything down. And there's one key reason why.
Hmm.
As soon as that expert writes a written report and sends it to me, it's now discoverable. And I have a duty, a legal and an ethical duty, to provide it to the state. Okay, it's
Oh.
in my possession. In this particular example, we hire this expert and we give him some marching orders. We want to know X, Y, and Z. And he calls me and he says, there was no power loss. I
Hmm.
completely agree with the Tennessee Highway Patrol's evaluation of this case. What your client's telling you is not true. Well, if he writes that down in a report and I provide it to the state's going to call my expert to say you were the defense's expert and you agree with us. So before we ever get there in that situation, I get on the phone and I go, tell me what you think. And he tells me, and I go, great, we're not going to use you. Don't ever write that down. I'll send you a check for your fee.
Wow. Okay. Just this is just making sure you don't get shot in the foot, basically.
Right. Yeah. Because if he says what I want, I tell him to put a report in place and I send it to the DA's office and that settles my case.
Mhm.
But that doesn't always happen. Right? In a murder case, I wanted to argue that there was a vagus nerve event that happened when a guy got shot in the neck. And that was what I had come up with through my research. And my doctor says, nope, not true. That ain't the case. Well, I don't need you then. I'm going to pivot and go a different direction.
Mm.
So you've got to make sure that your expert understands that, because it can really torpedo your case if they send you over a report that shoots you in the foot.
Right.
They got to understand that. And then you can get a pretty good idea of how well they testify by practicing with them, right? You want to practice with them. I'll tell you another area of experts that are really helpful that we use more often than not, I don't know that everybody does. I think they should. I may want to hire a doctor or an engineer to come into court, but I don't know for sure if I need to until I can effectively and intelligently interview the state's expert. The state's expert will talk to you. So a good example, I had a case, this just happened a couple months ago. Got a first degree murder case. The state's medical examiner, their forensic pathologist, came up with a conclusion that we don't like. We hire our own medical examiner, our own forensic pathologist. But before we use him in trial, we have him write specific questions for us to ask the state's medical examiner in our interview. So he writes us a script on how to interview her. And now we're not even going to need him, because through the questions he gave us, when we interviewed her, we changed her mind. And now she agrees with us.
Wow.
I could never have interviewed her so effectively without the questions and the information that I got from my expert. I'm not going to use him in court because I don't need to anymore.
Mm.
But he educated me about what I needed to ask.
Right.
And that comes up a lot in computer experts. That comes up a lot in engineering experts, forensic pathologists, medical examiners. Because I'm not a medical examiner, I'm never going to be. And I can read their books as much as I want, but I don't fully understand it. And that's not my role. So I get somebody that does to educate me and teach me how to interview them. It also works for trial. They can formulate questions for you to ask in preliminary hearings and trials of experts. So the state never has to know I have this person because they're only educating me.
Right, right, right. So that's why, which is also pretty much the reason why you don't have them write over anything to you or send you anything that could be of evidence. Okay.
Right.
Okay. All right. I feel like I'm to some degree I'm getting I'm getting schooled as well. Okay. So now on to the next. So we have the next thing is going to be on cross-examination techniques, right? So like, can you share effective cross-examination strategies that you employ to challenge prosecution's case and strengthen defense during courtroom proceedings?
So cross-examination is probably my favorite area of what I do, and I would venture to say is one of the most favorite things that any criminal defense attorney does. Cross-examination wins or loses your case. There are a couple of different theories on how to conduct cross-examinations. The most prevalent one, and the one that is used most often in my opinion, and is the one that I use most frequently, is developed by an attorney named Terry McCarthy, and it's called the McCarthy Look Good Cross Method. That method requires you to ask close-ended, short, concise statement questions that only solicit one fact per question. The idea being you ask short, concise questions eliciting one fact per question in an effort to get the witness to only say yes or no. I want to ask you a short question. Was there a car? Yes. Was it green? Yes. Was it traveling down this direction? Yes. Was it traveling down this direction with two occupants? Yes. Did you see gunfire come out of that car? Yes. That method is about control. It is about what is important in that method is not the answer, is the question. And if you can get a witness to start saying yes, they get in a trap of saying yes.
Mm-hmm.
But more importantly, what you're signaling to the jury is that you know the answers to the questions. If you sit up there on a witness stand and you say yes to 60 questions that I ask you, and then you say no to the last one, the jury's going to believe it was really a
Right. Right.
you say
Right.
no to the bad fact, and at
Mm-hmm.
that point, I don't even really care what you say because I've just shown the jury that you agree with everything I say. My question is important, not your answer.
Mm.
Very frequently, you leave the last answer to the end that you really want to ask, and then you don't even care if they answer because the jury's already seen that you're right. That takes a lot of preparation. It takes a lot of, it's difficult to master. There are classes, there are whole colleges you can go to. I've had a lot of training on cross-examination. It can win your case or it can lose your case.
Hmm.
Uh, I think the Terry McCarthy look good cross method is spectacular. The other prevailing method was created by two gentlemen named Posner and Dodd, and they believe that cross-examination is a science, not an art form. And they have some ways of asking those close-ended yes or no questions, preparing those questions in a way that you can solicit testimony that benefits your client and also fits your theme and theory of your case. The McCarthy or the Posner and Dodd method believes that you should never have to put your client on, that you can always solicit testimony on cross-examination from other witnesses to get the same facts into evidence. Um, I use these two methods. They are my primary methods.
Hmm.
There is an emerging method called dynamic cross-examination that is it scares the crap out of me. Um,
Why?
because it's either going to be the most effective cross-examination you've ever done, or it's going to lose your case for you. So the difference is in Look Good Cross and in McCarthy and Posner and Dodd, you are maintaining control.
Mm-hmm.
You want them to say yes or no. You want them to say yes when you want a yes, and you want them to say no when you want a no.
Mm.
The proof is in your question, right?
Mm-hmm.
In dynamic cross-examination, you are not just asking questions you know the answer to. You are building a narrative with the witness with a bunch of easy questions with the idea that at the end of that narrative, you're going to ask the dynamic question. A good example of that is getting a witness to define things for you. How do you define this? How do you define that? How do you define this? And you walk them down a path through their definitions that when you ask your dynamic question, the question you don't know the answer to, they can't back away from it because they've just put themselves in a box with their own definitions.
Mm-hmm.
If you do it correctly, you can win your case on that one question. If you don't do it correctly, you're rolling a bomb out there that they could disagree with you on and convict your client. It takes a lot of practice, and even in that method, they suggest that if you start losing control, that you just immediately go back to the Terry McCarthy look good cross method because you don't want to get your client convicted because of a dumb question you asked.
Mm.
I've been working on the dynamic cross for a long time now. I've used it in preliminary hearings. I've used it in motion hearings. I've used it a little bit in trial.
Mm.
I can see the benefits. I've seen masters of it do it so well, and I see the value. But I don't feel comfortable enough with it yet to employ it in like a really sophisticated criminal jury trial.
Mm-hmm.
But
Which would make sense.
I'm
Mm.
working on it. And you use your questions to advance your theme, which is the positive theory of your defense. You use your questions to advance your theory, which is the legal reason why your client's not guilty. My favorite crosses is of officers who are wanting to fight with you. Some witnesses answer your questions clearly, concisely, they're fantastic. Other witnesses want to get real cheeky. They don't like your questions. They want to fight with you about it.
Mm-hmm.
In those situations, you can regain control by asking them a universal truth question. So in an officer situation, you ask an officer a yes or no question, he gives you 40 words in response. And you're like, bro, yes or
It's
no,
just yes or no.
come on. And the jury can see that he's running from your question. So
Mm-hmm.
how do we rein him in? Well, you ask him a universal truth, and you hope that he disagrees with you, because then the jury's going to see he's unreasonable. Give you an example. You got an officer up there that is just running on your questions. He's not answering. He doesn't want to answer. He's hostile. So you ask him a universal truth. Officer, you carry a firearm.
Mm.
Yes. And that firearm is intended to be a form of protection, both for yourself and for the citizens.
Mm.
Of course it is. He can't say anything but yes to that.
That's right.
If he says anything but yes, you get to look at the jury and they're looking at him like, wait a minute, what? Right? Like,
Right.
you know, and
Hmm.
and you can illuminate that he's being unreasonable by asking him a universal truth. If he denies that that's the reason, the jury can tell. They can tell he's just being cantankerous. He's just being difficult.
Mm.
And they don't like that, because by the time the jury gets seated in the box and listens to the proof, they want to hear it all.
Mm.
And when you start running from my questions, it gives them the feeling that you're avoiding them. And you can bring it back around. The best officers don't run from your questions. They own the bad facts.
Mm.
You ask them a fact that helps your case, they go, yep, that's true. But then this. And it gives them so much credibility with juries. Young officers think that they should fight with you, and all it does is alienate them from the jury.
Right.
Older officers that have done it before, they own the bad facts because they know that they got enough good facts to hang your guy.
Interesting. Wow. This one, yeah, this is a very deep one. Okay. So now, on mental health defense, right? So
Mhm.
like how do you understand and implement mental health defenses in criminal cases? Like what role does expert testimony and evidence play in your strategy personally?
First thing is meeting with your client and just getting a feel for, are there some mental health issues here? We've all met people that act a little erratic, that are a little funny, and you can identify, I think there's an issue here. I think there is. If you think there's an issue with competency, understanding the proceedings, understanding anything, it is incumbent upon you and required to seek a mental health evaluation, because people that are not competent to stand trial are not permitted to stand trial under our Constitution.
Hmm.
Thankfully, in that area, in the mental health area, if you have concerns, there are a number of avenues to get the state to evaluate your client for competency. They will actually send your client off to inpatient facilities to determine whether or not they're competent. You can
Mm.
do that on your own as well, but if you do that on your own, you don't have the same level of admissibility for their evaluations. So I've got this going on in a case right now, where Middle Tennessee Mental Health has said that my client is not competent, and next month he's scheduled to go do an inpatient evaluation. The interesting thing about that, though, is they can be not competent today, but if through treatment and medication they can be made competent, then they can still stand trial.
Oh.
And it has to be an extreme situation for you to be able to argue not guilty by reason of insanity. That is a viable defense. It is the rarest thing you've ever seen. I've seen people that are incredibly ill mentally, paranoid schizophrenics, be made competent to stand trial. I've never seen a not guilty by reason of insanity. I've seen it
Wow.
argued. I've never seen it successful, because the burden is so high, because all they have to do is appreciate the seriousness of the offense. There's a really famous case out of Chicago where a gentleman was a paranoid schizophrenic in a bank robbery case, and he truly believed that the FBI had replaced his eyeball with a camera. Well, just because he believes that does not mean he does not appreciate the offense and the proceedings against him. It just means he has a mental health issue.
Mm.
I will tell you that the vast majority of clients that we have that are involved in drugs or are in active addiction almost always have an underlying traumatic event and mental health issue that is causing the addiction, that they're self-medicating and is untreated.
Mm.
In those situations, it's absolutely incumbent upon you to get them the treatment that they need, because it has just a trickle-down effect. If I've got an underlying traumatic event from childhood that I've not treated, and
Hmm.
that causes self-medication that rises to the level of addiction, then that
Right.
addiction causes me to go sell drugs to feed my addiction. Well, it's a really compelling defense to treat the underlying mental health issue, put your person back in a position of complete sobriety, and then show the state, look at how he is now. And we saw this so much, probably 7 out of 10 cases during the opiate crisis, when everybody was taking all these prescription medications that were originally prescribed by their doctors and they became addicted.
Hmm.
And so you've got to identify that and get your client the help they need, because it will only benefit their defense. Even if it doesn't mitigate the fact that they committed the crime, it is so relevant and so helpful to sentencing. We don't put mentally ill people in custody, or we shouldn't. That
Hmm.
ends up
Yeah.
happening a lot, but we shouldn't.
Right. Yeah, that is definitely true. Because the one that really stands out to me the most is where the person has an illness and then they get treated and then they can still stand trial, which is, and you argue it and you don't win, which is I would expect for you to win that one. But
It's very rare. In fact, I've only ever had 2 people come back not competent. The first one, they were able to make him competent through treatment and medication, and the second one is the gentleman I was just referring to that has not yet been sent off to Middle Tennessee Mental Health.
mm, okay, all right. So cool. So now off to the next question here. Now this one is on post conviction
Mhm,
remedies and appeals, right?
mhm.
So like, what are the best practices you follow when handling post conviction remedies and appeals, especially when exploring options for clients who have been convicted?
It depends on whether or not I handled the underlying case, or I'm getting the appeal after someone else handled it. If I'm the one that handled the underlying case, then the appeal process starts before trial ever begins, because you have to preserve issues on the record for appellate review. If you don't complain about it at the trial level, you are forever barred from complaining about it on appeal.
Oh.
So if I think a statement should be suppressed, I have to file a motion to suppress at the trial level. If I don't, I've waived that issue on appeal. So if I've handled it at the trial level, I preserve every possible meritorious issue for appellate review.
Hmm. Oh.
Frequently, you argue motions that you know you will lose because you are required to preserve it for appeal. If I have handled the case, I've not handled the case, and I'm only getting it on appeal.
Mm-hmm.
The first step is to get transcripts of everything that happened and to read those transcripts to be able to determine if the issues that you want to argue on appeal
Mm-hmm.
have been preserved, so that you don't have to risk the Court of Appeals saying you waived that issue. Because after conviction, the very first step is a motion for new trial at the trial level. Then you get a direct appeal to an appellate court. And only after all of your direct appeals have been exhausted do you get a post-conviction relief petition. Frequently, I've done a lot of post-conviction relief petitions, and post-conviction relief says that something was unconstitutional about your original trial. The most common form of complaint in a post-conviction setting is ineffective assistance of counsel, that your trial lawyer did not do something they should have done. In those situations, step one is to get the lawyer's file. The file is the client's property, so you get that other lawyer's file and see what they did. In a financial crime involving a lot of fraud and embezzlement, you would expect to see investigators, accountants, forensic accountants, auditors, people being hired. If you don't see those things, that's showing you that maybe that lawyer did fall below the standard of care and not provide effective assistance of counsel.
Hmm.
And so you've got to identify the issues first,
Mm-hmm.
and then you have to research them, and then you have to litigate them. And it's all going to depend on what your client says happened versus what that lawyer says happened. That's why, as trial counsel, it's incumbent upon you to write everything, put everything in writing with your client. We can have a long conversation about
Mm-hmm.
your liabilities, and I'm going to follow up with a letter saying this is what we talked about, so that you
Right.
can never come back and say I didn't tell you this.
Mm-hmm. Yeah, because it's all in writing. Because there's a belief now. Obviously, this is slightly going off the topic, but in the sales society, like in sales, basically, it is believed that when you show someone something, you want it in writing, basically. because people tend to believe what they see, and it's easily believable when it's there. It's an evidence, basically,
Right.
right?
That's right. And so, you want to first identify the issues. You want to identify what facts and law support your issues.
Mhm.
And then you file. You've got deadlines on appeals. The deadlines are real, and you've got to get those filings in on those deadlines. The courts of appeals don't care that your kid was sick. You've got to get it in. Um, and then also, it's really important to have appropriate level of client expectation on appeal. I have won appeals, but I have won very few. They are very difficult to win. I have won post convictions, but I've won very few. They are very difficult to win. You last thing you want is your client having some unrealistic belief that you're going to be successful on appeal. So you need to have a very frank conversation. I think this issue has merit. I think these issues have no merit. I think this issue has some merit, but the trending case law is against you.
Hmm.
And you just have to set their expectations. There are some avenues for reopening cases in Tennessee and in a lot of states, both for DNA and fingerprint analysis. I
Mhm.
have an Innocence Project case right now where my client's been in custody for 22 years. We were able to reopen his case and have DNA testing, and none of the DNA came back as his. So we're really creating a lot of fruitful argument for why he's been wrongfully convicted, because that's a real thing.
Hmm.
Um, in Tennessee alone, this year we've had 4 different people exonerated for crimes they didn't commit. One of them served more than 30 years in prison for something they completely didn't do. There's
Wow.
thousands of exonerees across the country, people that have served hundreds of years for things they didn't commit, crimes they didn't commit. So
Mhm.
when your client professes innocence, it's really easy to be jaded and not believe them. But what I would suggest is listen to what your client's saying,
Mhm.
and look at it and see. If you had told me a few years ago that the guy that I represent on the Innocence Project case, if you told me the facts of his case, I would have said he's guilty.
Mhm.
When you look below surface level and really start parsing out what actually occurred, very quickly it falls apart. And you can't always rely on the fact that he had great representation at the time. You just can't.
Interesting. Mm.
And so in our situation, we have 24 affidavits from people that say that this other person committed the crime. We have a complete absence of fingerprint and DNA. The fingerprints and DNA match other people, and he's been in prison for 22 years. No, longer than
What-
that. He went incarcerated in 98. So what is it? 24 years, 26 years now.
Wow. 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 So okay, cool. So I really am. I'm definitely tracking with this point. And I feel like now I can be like if there is such a status as that as a mini attorney. Uh, yeah, I feel like I've really learned a lot from you today. So pretty much that's all I got for you when it comes to the questions. I look forward to doing this with you again. And thanks a lot, Gordon, for being here with us today. And yeah, we'll be looking forward to the next one.
Yes, sir. Thank you. I've enjoyed it.
All righty.